We're ready to start our first afternoon session, and the title of it is Secondary Liability Regimes for Trademark Infringement Online. And ultimately, I don't know if it's going to be alternatives or variations on, so we'll see what they say. But in any case, I first want to introduce our moderator, and that's Barton, Beebe, professor of law at New York University, and he in turn will introduce our speakers for today.
Okay, good afternoon. So I'm here essentially to introduce the speakers and keep time. Our first speaker is Wendy Larson from Pirkey, Barber, based in Austin, Texas. And Wendy will be addressing the possibility of enhanced forms of liability for internet intermediaries. And then, in defense of the status quo, will come Tom Rubin, who is Chief Intellectual Property Strategy Counsel for a company called Microsoft. So we will have a debate about the sort of utopian possibilities versus just settling for what we've got, I guess.
Thanks, Barton.
Yeah.
Okay, so speaking of the best, is this the best we got? Is this the best we can do? I'm going to step back a little bit and talk about, when we talk about service provider liability, what are we actually talking about as far as the services that are being provided? There's a huge range of services provided online, and I think someone earlier talked about it's not enough to just look at who the people or who the companies are that are offering the services, but it's looking at what they're actually doing, looking kind of beyond the language of how we characterize things and look at what they're actually doing. So first of all, I'm a practitioner, so I represent companies, I represent brand owners. So I'm talking from a perspective of what do I see across my desk every day? What do I see across my desk during the week? I'm not necessarily concerned about what's showing up in the case law. Sometimes there's a huge disconnect about what's in the cases and what I'm actually seeing. When my clients say we came across this website, we came across whatever it is, sometimes there's no case law for what we're looking at. So here's the type of services that I'm seeing that kind of pose an issue for my clients. So domain name registration services, that's just the rote kind of a registrant decides on a string of letters, they want to register that, they go to a registrar, the registrar will process it sort of blindly and hand over the domain name. Privacy services, often that's offered by the registrar, so that's where the domain name owner is supposed to have their personal contact information appearing in the WHOIS record, but a privacy service, or sometimes called a proxy service, is offered where the proxy service will put their own their own personal information, their company identity in the WHOIS record, shielding the identity of the customer. Monetized parking pages, those are websites where you'll often come across them. They have a number of basically advertising links on them. Those are sometimes offered up by the registrar. Sometimes those are other entities that post those pages in connection with domain names. The monetized parking page ad content, that's provided by typically a different company. So often that's the Googles of the world supplying the ad content that they've contracted with advertisers to come up with that ad content. And then hosting services. We've been talking about hosting services already. Domain name auction services. So I've registered a domain name, decide I don't want it, or maybe I want to see if I can get some money for it. I'm going to list it with an auction service. Sometimes that's a registrar, like the GoDaddies of the world. Sometimes that's other entities. Social media, this is where we sort of get beyond the domain names, and it's, instead of registering a domain name to put up my own website for my company, I'm going to go put up a Facebook page and advertise my content that way, advertise my goods that way. Online retailers, we've been talking a lot about eBay, financial intermediaries, PayPal, for example, would be one of those. Email address providers, so those are provided by, like a Microsoft, for example, would provide a Hotmail address, Google might provide a Gmail address, et cetera, et cetera. Keyword advertising, I think we're all pretty familiar with what that is, but I'll touch on that briefly at the end. So, domain name registration services. So again, my part of this presentation is to talk about what can we do better? How can we hold service providers liable or implement better practices to eradicate or minimize infringement. We're never going to eradicate infringement, but to minimize infringement online. So at this point, to your question earlier today, why aren't we just cutting off the registrations, the domain name registrations early on? Why don't we go to the registrars, the registries, and once we have these repeat infringements, cut them off? So there's immunity for the registrars under the ACPA at this point. And that is because, when a registrar is following, when it's completely acting as a registrar, when it's only acting as a registrar, all it does is process that domain name, whatever string the customer has come up with. And when the ACPA was passed in the 90s, they wanted to make sure that the registrars had immunity for that and didn't have to screen for trademarks. So what's the problem? Well, so the National Arbitration Forum, which is an arbitration service provider for the UDRP, this is just one example. So there's one registrant that has 47 UDRP decisions against it, involving over 100 domain names, and here I've just listed a few of those examples of the kind of domain names they registered. The proceedings represent over $65,000 in filing fees. That doesn't count all the attorney's fees that went into preparing the UDRP complaints. The registrant used the same registrar for all of those names. It just seems like there's a point where, and to back up, the registrar is very involved in the UDRP process. So when a trademark owner files a UDRP complaint, the registrar is notified right away because they need to put that domain name on lock so that it's not transferred away during the pendency of the UDRP proceeding. The registrar also knows when a decision is rendered. So when there's a decision for the trademark owner, the registrar is the entity that will transfer the domain name to the mark owner. So this registrar has seen 100 domain names. It's been involved in all of these proceedings. It's not like it has no idea what its customer is doing. But the registrar has no liability for continuing this process or continuing to service, to provide services to this customer. So I would propose that registrars be liable under the ACPA once their registrants have violated either the UDRP or the ACPA a certain number of times. I think that's a negotiable number, but there's just a point where it's just too much. And there's obviously knowledge on the part of the registrar. And as I note here, in their policies, registrars already often reserve the right to do that, to say, domain name customer, if you violate third-party rights, we reserve the right to cut off your account. I think this could result in, so the registrar would obviously, when they cut off the account, they would need to give notice to that registrant. The registrant would likely move their entire domain name portfolio to another registrar. But at a certain point, there's a disincentive for that registrant to continue cyber squatting. Privacy service providers. So privacy service providers obviously hide the identity of their customer. The customer owns the domain name, presumably owns the content that's showing up on the website. Your identity is nobody's business but ours. That's one of the biggest privacy services slogan. So obviously what's the problem? They're hiding infringers. They're hiding other people too that have a legitimate reason to need privacy. There's a lack of uniformity in the way that privacy services handle objections. And there's confusion in the UDRP, and I would think even in the ACPA, the way that courts and panels have handled privacy services there. So as one who represents brand owners, I contact privacy services a lot. They are completely varied in the way that they respond to objections. So some of them will reveal their customer services information, or their customers' personal information right away. Some will never respond to you. Some will reveal their customers' information when you file a UDRP complaint. Some won't even do that. So they'll go through the entire UDRP proceeding, and the respondent is the privacy service. And then others will only reveal their customers' information if you file a lawsuit where at that point, of course, there's monetary damages involved, and they want to step aside and get away from that. My proposals would be One, that we need uniformity in practice. So ICANN doesn't require privacy services to act in a certain way once objections are sent to them by brand owners. I think there should be two contact options in the WHOIS record itself. One, saying if you want to contact the privacy service to complain about our customer and what they're doing, here's the contact information. And two, if you want to contact the customer directly, here's that contact information. I think there needs to be clear liability on the part of privacy services. I would argue that they are already liable if they don't get out of the way. If they're listing themselves in the WHOIS record as owning that domain name and controlling that domain name, and will not give you their customers' information when you ask for it, I would submit that they have taken the risk of whatever liability is attached to that website and that domain name. The current registrar accreditation agreement says that privacy services need to just have a clear policy. They don't say what that needs to be, but it needs to be clear, and they need to have an abuse contact email, but don't say where it needs to be. There's a provision on the RA already that says if there's a party in the WHOIS record saying that the website and the domain name is actually controlled by somebody else, yet they don't get out of the way after being notified within 7 days, they're liable for the harm caused by the wrongful use of the domain name. So I would propose that should apply to a privacy service. Monetized parking page providers. So here we have the domain name columbiauniversity.co. Somebody has registered this through GoDaddy as the registrar. GoDaddy's posted a monetized parking page, which, as you can see, has links on it. The links are generated, the content is generated by the terms in the domain name very often, not always, but very often. Here you can see there's links that say online colleges, '*S, Keller Graduate School, online degree program, things that are obviously related to education. The other links, I have to say, are probably generated from searches I was doing in connection with other work. So in the way that GoDaddy, the registrar, will put up, or whoever the parking page provider is, will put up the sort of the structure of the website, and then the ads usually come from a company like Google or some other ad content provider. Here, it looks like there's already direct liability under the ACPA. This is it's kind of a new kind of string of cases that's coming out. The Academy of Motion Picture Arts and Sciences sued GoDaddy a while ago and just had an MSJ handed down. GoDaddy said, hey, I'm a registrar. All I'm doing is I'm registering these domain names. I have immunity under the ACPA. The court disagreed and said when a registrar is doing more than just registering a domain name, so for example, putting up advertising on an unused domain name, you don't get that immunity anymore. It held that GoDaddy is an authorized licensee under the ACPA, and that GoDaddy uses and traffics in domain names in its Park Pages program. So, the implication here is this is the ACPA. So this is liability. This is statutory damages up to $100,000 per domain name. And this is a practice that GoDaddy and other registrars do routinely. So my proposal here, as far as enhancing liability, I don't think we need to. I think that the standard is there. There just needs to be education for brand owners and for the registrars to change this practice. I think this practice can be legitimate and doesn't necessarily need to infringe on brand owners' brands. I've heard that there's a patent floating around out there by one of the registrars that would essentially help them to block parking pages from domain names that are infringing on brand owners' marks. So again, potential for innovation there. There's a potential for those registrars to license their patented technology to their competitors and make some money off of it there. So we'll see what happens in the next few months, I guess. I'm going to kind of quickly skip through this. There's also a decision that said the ad content provider could be liable under the ACPA for providing the ads that show up on those parking pages. So now we're going to get into more of what we were talking about this morning. So the other types of internet service providers, hosting services, online retailers, financial intermediaries, social media, domain name auction service providers, and, well, these two at the end are probably new. I think all of these, they're going to be a proposal for change that's sort of a common proposal. So obviously we've been talking a lot about the Inwood Lab standard today and how that's been applied in different circumstances. Just again, really briefly to go back to what the standard is, that second part of it really is probably going to apply to these types of service providers. Continues to supply a product to one whom it knows or has reason to know is engaging in trademark infringement. Then it was later applied to services, later applied to online services. The courts are going to look at the degree of control in the service provider offering the infringing activity. Again, I think we've kind of gone over the case law here. Okay, so the point is the Inwood Lab standard has already been applied. It's already almost a notice and takedown situation already. It's been applied in the hosting service context, and it's been applied in the online retail context. I've seen it also applied in the financial services context. It was the tell me, Barton.
Frontline processing.
It was another one I'm thinking
Gucci v. Frontline Processing was one, and then
the point is it's been
perfect
10. It's been applied in the financial services context as well. It's not always successfully applied from a brand owner's perspective, but it has been applied. So it seems at this point that we're accepting that the Inwood Lab standard applies in this online service provider context. I think it would also, if it were tested in the social media, the domain name auction service provider, and the email address provider context, I think it would apply there as well. So is that enough? Should we accept just the Inwood Lab standard and the and just let the kind of the common law be our guide and go nowhere from there? I would think that we need to amend the Lamb Act to add sort of a notice and takedown type situation, like with the DMCA. I think it's already, the case law is already going there, but I think to add it to the statute would create certainty in the law. Inwood Labs was not a trademark. It was not an online service provider case, although it's been applied in different jurisdictions to be. I think there would be a number of. Well, I've come across a number of service providers that don't understand why they should follow a case in some other jurisdiction. But if it were codified in the Lanham Act, then it would be a lot clearer, a lot easier to enforce across different types of situations. From conversations that I've had today, I know there's going to be very lively debate about the wisdom of doing that. So I look forward to having that discussion further. But that would be sort of an overarching suggestion for more of the secondary liability type situations rather than the direct infringement type situations, which was kind of the first part of what I was talking about. Keyword advertising. This is an issue that's really had a lot of attention in the courts over many, many years. It's really not something that I see in my practice as being an issue really anymore. I think part of that is because some of our clients do it. I mean, they want to use their competitors' keywords or trademarks to advertise their own products, and not all of them, but some of them. And so I think there's just, as far as changing the law or making any enhancements there, I think it would be really hard to find the will, at least kind of from my perspective of who I represent, to do that. And I think there's really no will on the other side either to do that. So those are my proposals, and I look forward to furthering the discussion.
Good afternoon, everyone. Thanks, Barton, and thank you, Professor Ginsberg and the Kernochan Center for inviting me to this symposium. It's great to be back at Columbia, and this has been a great conference so far, and we have a lot to come. The topic that we're talking about today is important, certainly, and focused discussion on it is timely. Online brand enforcement is an issue of ongoing concern to me as Chief IP Strategy Counsel at Microsoft, and I'm excited to be here talking about it. Before I commence my speech, I just want to tell you that about half an hour ago, as I was walking in the hall coming in here for the afternoon session, this session focused on secondary liability for trademark infringement, I happened to pass by a poster that was placed by the Columbia Law Review, which is, I'm sure, a great production. I wish I could be here for it. But as we're talking about secondary liability for trademark infringement, I think we should maybe invite Pixar, perhaps Hasbro, and others to have a look at this. And along those lines, we've got, Columbia University, which, as Barton pointed out, is a very deep pocket, on whose walls this has appeared and who appears to be sponsoring this. We have any lawyers from Schulte Roth or Sidley Austin? It was very nice of you to sponsor this, but who knows, you may be on the hook now. So let's move into secondary liability now in the online world. So I've been assigned the task of defending the current legal standard for assessing online service providers' secondary liability for trademark infringement. In other words, I've been assigned to defend the status quo. I think it's fair to say that at an academic conference, that's not the first option that most people would pick. It's like being asked how to prepare meatloaf at a conference on new trends in the culinary arts. That said, with respect to the current law of the land in the U.S., I don't totally shy away from that position. To be clear, it's not my position that the current state of affairs is perfect, as there are real challenges facing brand owners, challenges that I and Microsoft truly understand. Microsoft is, of course, an online service provider, and our online services like Bing, Skype, SkyDrive, Office 365, and Xbox Live are both important lines of business and valuable services that hundreds of millions of customers around the world rely on every single day. At the same time, Microsoft also owns some of the world's most valuable brands. And as a brand owner that is victim of substantial online, and we are a brand owner that is a victim of substantial online infringement. Our infringement battles run the gamut from pirated and counterfeit software to counterfeit hardware, like computer peripherals and game consoles. The damage caused by these infringements is estimated to be in the billions of dollars annually. And as you may know, Microsoft expects to complete its acquisition of Nokia's phone business early next year, which will only increase our counterfeiting and IP enforcement challenges. Further, I've personally had experience combating infringement as an assistant United States attorney here in the Southern District of New York. Before I went to Microsoft 15 years ago, I was an AUSA here, and I can remember it may have actually been my very first case where first search warrant that I remember working with an agent and drafting and bringing to a judge was for, if I remember it exactly right, it was the third stall with the red door off the southeast corner of Mott and Houston Street, where we were raiding it in order to seize Chanel handbags. And I continued when I was in the U.S. Attorney's Office as prosecuting intellectual property and computer crimes. And so, I also saw from the government enforcement perspective just how challenging that could be and also how important that task is. So I do understand the importance of effective enforcement for brands and the challenges there are to getting the job done. For that reason, I believe that we should carefully consider all reasonable proposals that would enable trademark owners to more efficiently protect their brands against consumer harm and commercial threats. But before turning to legislative solutions that disrupt the current legal regime, I think we must take care and consider two big picture questions. First, what's been the result of the current regime? Are platforms being rewarded for good behavior and held liable for bad? Are there greater opportunities for effective enforcement under current law? Or is the system inherently broken? And second, What's the likely result of a change? How would a higher duty of care impact the vitality of the internet? What's the likely impact to the integrity of the intellectual property system? And what about the economic impact? It's with insights into the answers to these questions that I think we can best evaluate the pros and cons in a change to the legal standard. And so I'd like to spend my time talking through them. So first, as to the current regime, at a high level, the law of the land is developed through federal case law is that for online service providers to be secondarily liable for trademark infringement, the provider must either intentionally induce another to infringe, or it must continue to offer its services to an infringer with specific contemporary knowledge that the infringement is occurring. To bring real-world color to the way this has been applied, let's look at the facts surrounding two cases. eBay successfully defended the Tiffany suit in part based upon an impressive record showing that it took a long list of actions to partner with Tiffany and other brand owners to support their enforcement efforts. Among other things, eBay maintained a robust notice and takedown system and typically processed those takedowns very quickly. eBay implemented a repeat infringer policy. eBay suspended hundreds of thousands of sellers every year suspected of engaging in infringing conduct. And eBay promptly removed all listings that Tiffany challenged as counterfeit via its notice and takedown system. eBay went even further than typical notice and takedown best practices, including by establishing dedicated pages on its site where brand owners could post educational materials for consumers, and by implementing a fraud engine to proactively search and take down listings that violated its policies. I hope we can all agree that these are precisely the kinds of actions that brand owners want to encourage platforms to take, and eBay was rewarded by the court's holding. Now contrast that case with the very recent California case from, I think, October 8th in the Central District of California, Chloe versus Sawabe Information Services. In that case, similar to Tiffany, Chloe and other Richemont-owned luxury good brands sought to hold the owner of an online swap meet called Turnkey liable for hosting the offer for sale of counterfeits on its website. Chloe worked with an investigator posing as a seller to build a record regarding the platform's actions, including, upon notice by the investigator seller that goods being posted for sale were counterfeit, the platform affirmatively responded that it was okay for the seller to be doing that, and that indeed many of the goods on its site were replicas. Also, the platform assisted the investigator with keyword optimization to drive traffic from users actively seeking the counterfeit listings. The platform modified ad copy for the listing to change the characterization of goods from replicas to fashion handbags, which the court interpreted as evidence that Turnkey was trying to hide the real nature of the goods being sold. Compared to eBay, this is a tough record to defend against, and not surprisingly, the Chloe case resulted in secondary liability for Turnkey. Now, I'm just using these two examples in the interest of time, but here's the bottom line. In most cases, the courts are getting it right. The current standard has resulted in decisions that reward good behavior and punish bad behavior by platforms. Platforms like eBay have created multiple measures to protect brand owners, including building systems that allow for notice and takedown, despite the absence of a DMCA-like duty to do so. As a brand owner, we at Microsoft have worked closely with eBay and have found them to be good partners and highly effective at addressing our takedown requests. And as an online service provider, Microsoft too has such a system, and we're proud of our response time across our services. This is the tool if you go to any Microsoft online site and you go and to report infringement relating to that site. Here is the tool that you see. The first screen is what we first show, where we list the online services, and the second is the complaint form that brand owners, and trademark owners, as well as copyright owners can fill out. This isn't unique to Microsoft. Our experience is that most other reputable online service platforms, and even some less than reputable ones, have implemented similar notice and takedown systems that have proven effective. And for platforms that do not responsibly partner with brand owners to receive and address notices of infringement, or that try to thwart notice and takedown efforts, or that take an active role in promoting counterfeiting, the current legal regime provides room for liability. But if I'm a brand owner, which of course Microsoft is, I might be thinking that without that notwithstanding that, notwithstanding that the court seemed to be getting it right, the current system places a heavy burden on me to identify and provide notice to online platforms. So perhaps I conclude in that instance that I want a solution that lessens the difficulty of doing this, or that places a greater duty on online service providers to combat infringement even in the absence of notice from me. As a result, one of the ideas being discussed among brand owners is to increase the duty of care on online service providers. I'll talk about why I think this would likely have unintended and undesirable results in a moment. But first, as a rights owner, I'd like to share how Microsoft has worked within the current legal regime to combat online infringement. I'd like to share our experience employing what we believe are the right resources and the right strategy to bring online infringement down from what was once considered a significant threat to our business to a controlled level. The first task is to understand the scope of the problem, how to measure it, and how to measure the effectiveness of enforcement efforts. Nearly 5 years ago, Microsoft implemented a new strategy for combating online infringement by leveraging notice and takedown in a more significant way than it had before, with a particular focus on piracy. It's, of course, been hard work. In our last fiscal year, Microsoft took action to remove about 19 million infringements from the internet, issuing on average 1.5 million takedown notices per month to online service providers. The graph here shows you how over the past several years we've ramped up our use of notice and takedown. And the chart on the bottom is actually from Google's transparency report. You may know that they, maybe it was about a year ago now, I forgot when they first released it, but they provide information on who the biggest filers are of takedown notices. And lo and behold, there you see Microsoft as number 3 in the month that we have captured here, which gives you an idea of our volume and our relative volume to others. Now, looking at these numbers, that's a lot of takedowns. But the important thing to realize is that we're not singularly focused on quantity. Indeed, measuring success based on quantity would be a fool's errand, as we know that at any given time there are roughly 28,000 websites offering access to pirated Microsoft products. So above all, our strategy focuses on relevancy. In the piracy context, we assess relevancy in relation to how long it takes an average user to find infringing Microsoft content, not on the absolute number of infringements. And through efforts that analyze internet traffic patterns and user habits, it now takes an average user several minutes to find infringing Microsoft content online. So I want to show you this graph, which is just it shows in graphical form this metric that we use, which are data points from late September to late October, and using a search that, as I say, is conducted as if it were an average user of the internet, because, of course, what I think that most intellectual property owners are seeking to prevent on the internet is the what turns out to be sort of everyday searches for infringing content. If you look at that and you put yourself in that position, we've been able to successfully increase the amount of time up to 10 minutes. And on the days actually where there are no dots, that's because infringing content could not be found in virtually any amount of time. Now, it's, as I say, this was a very large shift for Microsoft in how we viewed our enforcement program. Again, going from quantity to essentially the quality of the takedown that we were doing and how effective that it is. And the reason why we think that measuring this way and having a time measure is certainly a very relevant consideration is because, given the behavior of internet users, they typically give up after a while, and therefore we do end up targeting the most harmful instances of infringement. Relevancy is also the focus of our brand-specific enforcement efforts, such as with respect to infringement in online marketplaces and domain name disputes. There, we utilize tools that assist us in finding and ranking infringements based upon relevancy factors that we've identified, so that we're able to quickly take action against those that are the highest priority, such as infringements associating our brands with pornography, or those that are most confusing for consumers. We also know, of course, that the worst infringers don't typically infringe once. For example, parties that own one infringing domain name, as we heard earlier, often own many. Parties posting infringing apps will often publish more than one. And the party making one instance of pirated software available will frequently make the software available widely. So zeroing in on where those parties are located gives us insight into hot zones of infringement. Our enforcement team has been able to create visualization tools that help us locate those hot zones and thus focus our enforcement efforts accordingly. I just want to share with you what that looks like, which is, this is a map of the world which has superimposed on it. The overlay are where we have detected infringements, and the larger the circle, the greater the number of infringements from around the world. And what we're able to do, which is very helpful in an investigative sort of way, is you're able to zoom in. So here we are in the northeast corridor of the United States, where we're able to pinpoint where the largest number of infringements come from. And then because here we are at Columbia, I had to see whether any of you were up to no good. And so here we are in Manhattan. I'm really happy to say, if you look at the top center of this map here, you see that there's actually no dot over Morningside Heights. So congratulations. I will say that I've given this presentation at other university settings, which shall remain nameless, and they were very hot. But Columbia, kudos to you. Another example of a best practice is a technology that we've used to target problematic domain name uses. As you may know, current domain name registration rules don't provide an effective remedy for inaccurate or masked registration information, which often renders it impossible to identify the party behind an infringing website, or to run a reverse whois report and identify other domains being used by that party. But we've been able to use a tool that identifies the IP address for a bad site and identifies IPs nearby that would be related to that IP address, and which resolve then to obviously related websites. This helps us better identify related infringement, and it helps us prioritize our enforcement efforts, mainly by using the notice and takedown systems of the appropriate platforms, including, by the way, our own platform. That is, we follow our own notice procedures as if we were dealing with an external party, which provides us with important data and the feedback loop as to how well our own takedown system is working. Now, of course, all this progress came at some cost, and I know brand owners worry about the expenses of enforcement. We certainly do. My response is that brand protection has always required expenditure of resources, and it's unreasonable to expect anything different in the context of the internet. Just as stores install alarm systems to protect their merchandise, and office buildings hire guards to deter vandalism, and brand owners fund undercover operations offline, this one, brand owners simply need to invest in online tools to protect their trademarks. But with a bit of investment in the right tools, this type of enforcement is cost-effective and it scales well. Using Microsoft's example, the cost per infringing file that we were able to take down last year was literally pennies, which we have found to be a very worthwhile investment. So the lesson here is that today, the law and the courts are generally getting it right. Legal precedent that rewards good behavior and punishes bad has encouraged the creation of workable takedown systems by most major platforms. So with the implementation of rights owner best practices, which I believe is a woefully underlooked area of opportunity, those owners can leverage these systems and start to contain the infringement threat to their business. In doing so, they can protect consumers from confusion at scale and at reasonable cost, which is the ultimate policy goal of trademark law. That is the status quo. So with that in mind, I'll turn briefly to what I think would result from a change in the law that imposes a higher duty of care on service providers, specifically the proposal to impose a constructive notice standard. Under this proposal, an online service provider would be liable for trademark infringement by a third-party user of the provider's services, even if the provider did not know of the infringement, but merely should have known. This has been discussed in the U.S. and has most recently been raised by some stakeholders in light of recent revisions to the trademark law in China. By imposing liability without actual knowledge of infringement, it would mark a sharp departure from long-standing principles of secondary liability. As the Second Circuit in Tiffany held, eBay had no affirmative duty to address each infringement unless it knew or had reason to know of specific instances of actual infringement by particular users of its site. The constructive notice liability proposal would be a 180-degree departure from the standard. Before undertaking such a fundamental change, it's important to take a close look at what its effects would be. I'd like to raise 4 issues that I think should give substantial pause in considering such a proposal. First, a constructive notice standard assumes that online service providers have the ability to clearly and accurately identify trademark infringement on their sites. As Tiffany and other cases demonstrate, this is false. It's far more difficult to detect trademark infringement than copyright infringement, which can rely on digital fingerprinting technology, as YouTube does. That technology would be ineffective in the trademark context because there are no clear reference copies to operate from, and there are many more fair and legitimate uses of brand names than there are of entire songs or entire movies. The problem then is that online service providers are not and cannot be trademark experts on the millions of products that might be offered or sold via their services. And they don't have the necessary expertise to distinguish between genuine and counterfeit goods or between legal and illegal resellers. Unlike Justice Stewart's observation about pornography, outsiders can't know it when they see it. The indicia of counterfeiting that are often suggested, such as prices of counterfeits relative to retail pricing, the volume of sales by a single user, the quantity of an item offered, and so on, are largely subjective and are not robust and objective tests for identifying infringement. Hence, brand owners are much more capable than service providers of identifying infringement of their own trademarks. Second, even if these approaches for identifying counterfeits were robust and reliable, they would require service providers to review the activities of thousands or even millions of users every day. Because this infringement identification process cannot be fully automated, it cannot scale, so it would be prohibitively expensive and time-consuming for any significant providers, such as eBay with its millions of transactions daily. At best, these additional costs would be passed on to consumers, but more likely, many innovative platforms would no longer have viable business models. Third, because online providers often would be unable to distinguish between legal and illegal trademark uses and would naturally want to avoid untold liability, we can be sure that a constructive notice standard would lead them to resolve even remotely close questions about fair use in favor of removal. This would imperil many important, legitimate, and fair uses of trademarks, including uses that clearly enhance competition and have undeniable consumer benefits. Any legal rule that results in a suppression of speech would understandably raise substantial concerns of netizens, and it bears noting that the value of free speech has been a major catalyst for the growth of the internet and even political empowerment. Fourth, we also need to take into account how such changes would affect the broader internet from an economic perspective. Online service providers, search engines, e-commerce platforms, app stores, and others have directly and indirectly created millions of jobs and sparked unprecedented innovation and consumer value. The internet is responsible for an astounding 21% of total GDP growth in mature markets over the last 5 years, according to a 2011 McKinsey study. Any new legal duties imposed on online service providers must not jeopardize these gains and imperil businesses online. But that's just what a constructive notice standard could do. Forcing platforms to choose between uncertain but potentially enormous liability or policing of its users in a way that doesn't scale and undermines the utility of the service is no choice at all. The current state of the law in the U.S. avoids both of these outcomes. Indeed, rather than disrupt the rules that we enjoy in the U.S., which after years of litigation finally provides a degree of clarity about enforcement strategies to all players, I think the trademark bar should be focused on how to achieve similar clarity and consistency around intermediary liability abroad. For instance, as you know and we heard earlier, the European Union operates under the eCommerce Directive, which creates an EU-wide structure, but each member state implements the directive through its own laws. The lack of uniformity creates significant regulatory and compliance costs for online service providers while providing questionable real benefit to brand owners. In short, a constructive notice standard would place an ineffective trademark enforcement system on the backs of consumers, the economy, and society. We can do better. I'd like to conclude by again emphasizing that Microsoft recognizes the significant threat that online counterfeits can pose to brands. We're dedicated to improving trademark enforcement to better protect companies, ourselves included, from bad actors online. Indeed, we've demonstrated our interest in engaging in efforts to improve the system by negotiating and embracing voluntary measures that improve the position of brand owners. In the trademark space, for instance, we've partnered with several other leading display ad networks to develop a series of best practices to keep ads off of certain counterfeiting sites. We also participate in the nonprofit Center for Safe Internet Pharmacies, along with other online platforms. And in the copyright space, we've worked with stakeholders, including rights owners and platforms, to develop the user-generated content principles. So rather than impose onerous and untested new liabilities, brands and online service providers should work together to develop best practices and technology that help all of us detect and remove infringing content as quickly as possible. As we've found in practice, this focus can result in very effective online enforcement under the current law. I look forward to continuing to discuss this topic with all of you now and going forward. Thank you.
So we have a good deal of time for questions and answers. If there are any in the audience who wish to ask questions of our panelists. I'll start then by asking one question, and as others collect their thoughts. And I suppose the question is tangentially relevant to what you're both just talking about. This question about small business owners and how they navigate these sorts of regimes, either the regime we have or regimes that are proposed. And it goes to a few things that were raised earlier today about, we're talking about Google and eBay and Microsoft, and these are incredibly massive, incredibly sophisticated companies who can marshal all sorts of resources to monitor websites, to issue over 1 million takedown notices per month. It's extraordinarily impressive. But if there is some political currency to the small business owner in like Washington, for example, how does one advise a small business owner in dealing with something like this? So let's say, in New York terms, a small fashion brand that doesn't have the staff to continually monitor eBay. How do they deal with this notice and takedown regime? And would they actually possibly benefit from what I agree is a risky strategy, which is the constructive notice strategy? So that's on the rights holder side. And then maybe just to build out this a bit more, clearly it would seem that there's no chance I could ever have to open up my own auction site because Tiffany v. eBay has established a sort of model of best practices that arguably creates a barrier to entry to new participants who would have to build out this huge administrative apparatus. What this seems to lead to, and maybe this is just the nature of the internet now expressed in a new way, is the sort of, I don't know if you call it a network effect or something, winner-take-all sort of logic to the internet, but it would appear that the system we currently have massively benefits the Goliaths against the Davids. And I'm not sure, maybe we just have to put up with that. So that's the general question. What about small business people?
So I guess as far as the first question, if you have a small company in New York that has fashion, that has a fashion brand, for example, I guess on the one hand, I wouldn't think infringement would be as big of a deal. So you have a Coach, for example, and they've got infringement all over the world, and they do have to send out notices and take down notices. But with a small fashion brand, I would imagine it would be the more successful you are, the more you're going to be imitated, and hopefully the bigger budget you have for a team of trademark attorneys to help you with that. I guess that would be the short answer to that one.
We hear a lot about the plight of small business owners, and they're certainly sympathetic, to be sure. I do think, as Wendy just sort of alluded to, I mean, there is somewhat of actually a lack of study of the actual plight of small business. Is the small fashion company, in fact, as Wendy said, suffering from this? So I think that, one thing, especially we're here at Columbia, I'd say that the Academy could actually help in this area by engaging in more research into the actual scope of the problem, rather than have small business owners dictate outcomes if, in fact, they are not adversely impacted or unduly impacted. But I also think, I was talking, in my talk about rights holder best practices, I see no reason, and I've thought this in the copyright context for a long time, why the tools that Microsoft uses, the tools that others use, these are it's just technology. These are automated processes, and there's no reason why a third party. I guess actually there are third parties that do this for small business owners that do you can outsource your policing. And so it's not as if there's no recourse. If this in fact is having an impact on the economics of the business of any company, they do have the ability to go and hire someone to do investigations and takedowns for them. And I do think that probably the system can do even better in that regard, in that I think that maybe those, I don't know enough about the current state of the art of those companies, but there are some investigative techniques that I shared with you today that perhaps are not being employed that could make the system even better for them. Just on your second point, Barton, I would say I think that's a really interesting and important question about did eBay now set a new floor for auction sites? You could say the exact same thing, frankly, about YouTube and the content identification system, which those kinds of systems can only be employed by the largest. And what impact does that have? I think that is actually a very critical question, because it appears that we are ending up in a winner-take-all world, and that's not beneficial to the consumer.
That answer is implying that the consumer is not the winner, and therefore the loser, I guess. But I'm joking. Graham,
thanks, Bart. The question of Paul, I think your observation is quite right, that there's disharmony currently existing in Europe, but it's still relatively early days, and interpreting Article 11 is something that hopefully will resolve over time, though I don't think we should expect, maybe it's one world, but maybe we shouldn't expect solutions all in a matter of years. Sometimes the things take a little longer to work out. But in terms of the comparison of the American model and the European model, you were praising all the stuff that eBay did. My question would be, which legal model actually best ensures the kind of forward-looking measures that you defended and thought were acceptable and desirable, it strikes me that in fact they don't have to do most of the kind of things that you find helpful. Where under Article 11, those kind of forward-looking measures may be the type of thing that courts would in fact require, but would require, to pick up Barton's point, differently from differently positioned, from differently capable businesses. And therefore, it strikes me as oddly you are as critical of the European approach, other than the disharmony point which I take. Given that the type of thing that you think commendable, they are largely more likely to get under the European system than under at least the Tiffany version of the American system. That's one question. Second one, if I Barton will allow me, which is that even if you accept, Tom, your position, which is you want to stick basically with sort of the current American position, would you favor moving to a statutory rather than common law regime, which is a sort of still conservative but maybe slightly less conservative thing to do? And in that regard, I'll give you a quote from Fred Moster's article with Marty Schwimmer, who said, the lesson of academic is that you should take down and respond to a take-down notice even if it is written in crayon, which is that under the common law system, you don't actually know what is adequate notice, whereas maybe in a statutory system, you may have better guidance on it.
So thanks for that, Graham. I wouldn't begin to argue with you or even discuss with you the merits of the European system. I know when I'm out of my league. But I'm very interested in what you had to say, and I would actually love to just talk to you more about that. I really focus today on the American system because it's what we avail ourselves of most. It's what I'm most familiar with, and where we've had good results. But I didn't intend any of my remarks to be a literal comparative study of the American versus the European system, except for the one observation I made about lack of harmonization in Europe that makes it difficult for brand owners and service providers to actually have efficient and effective systems. On the issue of statutory versus common law, I think that's a important question, and I think that the common law, as I've seen it develop, is working out. I have seen, as I've alluded to, I've seen responsible platforms, and I've seen, frankly, irresponsible platforms, in fact, operate notice and takedown systems. That's not to say that every platform does, but some of the most nefarious service providers you can think of, in fact, have operated effective notice, at least responsive, I should say, notice and takedown system. But whether we're better off having the law address it, Congress address it, as opposed to the common law, is something that it would be very interesting to get more input from those of you who study this on a daily basis. I'm sure there are a lot of thoughts on that.
Can I just ask, what do you mean by a nefarious service provider? Is there nefarious in what way if they're really responsive to these kind of?
Well, there's some that have been sued and lost or indicted, et cetera, that actually were responsive to takedown notices.
June next.
This is a question for Wendy. You suggested that a way to improve protection for trademark owners was to adopt a DMCA notice and takedown type regime. Although I would have to say that from the copyright owner's point of view, that is not a universally popular statute, and they find it quite frustrating, as a matter of fact. If you look at the buyout companies, it's one of the principal problems is you keep having to file notices, and no matter how many times you file, you just have to continue to file, or the red flag statements and how that's. So I guess my question to you is, would you adopt that standard wholesale, or would you modify it for your new regime?
No, I think there's a lot of lessons to be learned from all the frustration from the DMCA notice and takedown regime and how it's really played out. So we were talking at lunch about how that would work, and I think there should be study about, how does it work, how does it not work, and then if we were to adopt a statutory standard, that we would take all of that into consideration. And on the trademark side, there's many different considerations as well. With trademarks, obviously, there can be a bit more of a gray area when it's not a counterfeit. And so there need to be consideration about how that would play out and what that wording would look like in the statute.
I guess the only thing I'd add to that, June, is you saw the statistics I put up there. On the copyright side, Microsoft is a very large copyright owner and has a very, very large problem with online infringement. But I guess I frankly challenge the notion that the current system can't be made effective for rights holders. Again, I go back to I think that there's much more that rights holders can do to avail themselves of what is available to them, and I think part of it is perfecting investigative and takedown resource.
I just wondering, the number of takedowns you're doing is truly stunning. And it doesn't
Thank you.
mind-boggling, but you're able to scale it up. Is there something intrinsic about what you do that allows it to scale up that the ISPs couldn't do the same thing? Is it just a matter of who pays for it? Why couldn't they do the same searching that you do and be responsible for the cost of it?
Because we know what we're looking for, and we know how to prioritize what matters. An ISP, not being the owner of that intellectual property, wouldn't know where to start or how to go about it. So we frankly are in the unique position of identifying infringements of our products and infringements that matter. So I do think that ISPs and content owners are very differently situated.
This is a follow-up to the last two questions. I'd like to know what both each of you thinks of takedown, stay down, which is in a sense a compromised position because it doesn't require upfront monitoring, which also has some problems in positive law, but it does, in effect, the initial burden of seeking out the infringement remains on the trademark owner or the copyright owner, but then it shifts once you've made that initial showing. Now, I recognize that between copyright and trademark there may be some differences that I think Wendy's point about you to be an infringee in trademarks, you probably have to have achieved a certain level of renown and therefore size. That's not true for copyright, and therefore the enforcement costs are higher for the copyright owner. And I suppose on Tom's point of you know what you're looking for, that's also different with respect to copyright and trademark, because for notwithstanding some fair use issues, frequently for copyright, if it's the title and the entire work, there's not maybe too much doubt about whether or not that's infringing. But so acknowledging that takedown, stay down may have maybe the most appealing solution on the copyright side, I'd still like to know what you think of it on the trademark side.
I guess my frustration is not so much when you ask for something to be removed and then it pops back up. I think more what I see is asking for something to be removed by somebody 1 time, 2 times, 3 times, 4 times, and that customer's account is never cut off. So I guess that would be kind of a variant of the takedown, stay down. It would, more of a kind of blacklisting of that account holder or that customer. Once they've proven themselves as having no regard for the trademark rights of others, then they should just be banned from doing that with that service provider. And there's issues with that. Obviously people can then just create a new identity for themselves, and there's nothing that would preclude them from doing that. But as I understand the current regime, it's I'm alerted to, as a service provider, I'd be alerted to one instance of infringement. I need to just take that down, and that's it. I don't have to ban that customer anymore, even though I might reserve that right for myself as a service provider. I don't see it happening I'd be curious to get your thoughts on that.
Yeah, so,
Before Tom, I
go on.
made a very important distinction between being kicked off and staying off. In other words, the person who's originating the posting, whether it's the same person originating the posting, and as opposed to the content that's posted. Because I guess take down, stay down, we mostly think of the same content being reposted by multiple different users. And this is a problem, I think, both in copyright and in trademark. So with that, that clarification.
So I agree that repeat infringer policies are really important and a very effective way of addressing the issue. It's not the full question that you're asking. It would help me to understand, actually, in the trademark context, the takedown, stay down. Well, just give me the archetypal scenario that you're talking about, Jane, so I can address that.
Probably counterfeiting.
So on eBay, is it that would be the example?
That seems like a good paradigm. Yeah.
Okay, so I mean, with takedown, stay down, the easiest example of that, where it would actually where it would scale because you just use an algorithm, is a uniquely identifiable digital file that has previously been identified as, in the copyright context, the full movie, a full song, etc. Because each file, there is a unique hash that each file has, and so you can literally find matching files given a pool of files. I just don't see how that translates, that level of accuracy translates in the trademark context. If you're talking about a counterfeit handbag appearing and then popping up somewhere else. I'm really thinking of what is the algorithm that a programmer is going to use that would enable the identification of that could render, take down, stay down something that would be effective and accurate. And I don't know what they look for.
Okay, how about words like replica?
Oh, well, the problem with a word like replica is that replica is certainly used in certain contexts for infringing counterfeit products. It is also it's frankly also a common English word that's used in other contexts as well, perfectly legitimate contexts. So that's the problem there, that it doesn't, if say the analogy to at least in copyright, you have the source file, you have the identical, it's essentially 100% certainty that they are a match. Replica, it may be that 70% of I have no idea, but let's just even say 70% of the time replica is an indication of infringement. That I would say, that you can't then map that to a takedown, stay down program, but you could say, well, that's a great place for a brand owner to start their investigation. But I don't see how it really provides the opportunity for an online service provider to operate a stay down program.
Susie.
So my question was for Tom, and it was a question about your graph where you had time, I think on the y-axis, and it was a question about clarifying how you use time. So two questions. The first is narrow. I think if I understood you correctly, I understand your reason for using time because it might give you better data. But time in what sense? One instance where someone is online for a period of time, and how would you take account, say, if they're online for 3 hours or 2 days or whatever, and then there's an interval, and then they go back online? Does it measure that at all, or is each instance, if I can call it that, a separate period of time? And in working out to use time on the y-axis, I think you said that the reason was because it gives you a better measure overall. My question is, what other variables did you play with before you decided on time?
So to clarify exactly what the time measure is, it's not how long an individual user has an internet session, it's how long it takes someone looking for infringing product that's specifically looking for Windows or Microsoft Office to locate a copy on the internet.
So either way, it's one instance, right? So if they did that 1 hour one day and then for the other hour next day, you wouldn't know if it was the same user?
Right. Well, this is not measuring a specific user. This is the metric that we use internally, where we have tools that put us in the position of the average user, and we see how long it takes to find the infringement. If the infringement, let's say, is high up in a search result and it takes very little time, that's the infringement that we target. You could do the same thing with searches on eBay, which is, I don't know how brand owners generally use eBay or prioritize their takedowns, but the content that matters is the content that's readily accessible to the average consumer. And I'm saying that's what we focus on. That's the metric that matters.
Well, that really leads to my second part, because I think, and really what I'm pushing you on is that's the metric that matters for that specific instance. But I think so is that the only thing that you would use that graph for? Does it only show that one outcome, that these are times that it takes to find an infringement?
Yeah, well, I'm saying that we came to a realization in our own enforcement efforts that you have to optimize for something.
Yeah.
And we have felt that, and it has proven effective, that optimizing for length of time for an average user to find infringing content is the best single way to construct a takedown program and to prioritize those takedowns. Thanks.
Yeah, just one clarification. Follow up actually on Bob's. The Google report that you alluded to in your presentation, I think it was titled Copyright Takedowns, or was I mistaken?
Yeah, that particular one.
How would you roughly at least say how much would be on copyright grounds and how much would be on trademarks grounds?
Of our takedowns, is that what you're? The vast majority would be copyright, but we have significant takedown enforcement across, domain. Just the stuff that we were hearing earlier from domain registrars and other online intermediaries. Less so in the Google search engine context.
So the numbers we saw were for both?
Yeah, those, I don't know how they, we'd have to look at it, but you can safely assume that those numbers, or the vast majority of them, are for copyright infringing content.
Yes.
I don't know why I'm so stuck on the GoDaddies and the network solutions of the world today, but this is what strikes me. In Trademark, we have a classification system for goods and services that commercial users have to adhere by when they're registering corporations for particular purposes. And we don't have that, as far as I'm aware, in any of the registration systems that exist. So my question for each of you would be, would it at all be helpful if, as the industry matures, there were some kind of division between family-based domain names and corporate ones, and within those categories, then we were asking them to subdivide and peg to state-based grants of licenses to do business that would make it easier for us to compare apples to apples within an infringing space. So whether someone is infringing in the handbag space, and I'm not trying to ask someone to do a takedown notice in California that has nothing to do with my particular business category. Does that make it easier for Microsoft to scale and look at, or does it make it even more helpful?
I'm sorry, but you're referring to categorizing in what space?
Domain name uses, actually. So if you go to register a domain name today, you can be anybody doing anything. It can be a private purpose, it can be a commercial purpose. Within the commercial space, it can be for any category. But for trademark, we ask people when they go to register a trademark to be very specific about the category in which they're going to use that presence. And as these universes conflate and we're looking at ways of preventing infringement, would it be helpful for you if that were transposed, that kind of burden went also onto the registrars?
I'd have to think. I haven't thought about that, and we certainly have a very large cyber squatting problem. It's a constant issue that we're dealing with. So that if you're Delta and you go to register, or you're someone who's seeking to register Delta, as, some variation of Delta as a domain name, you'd have to say what category. I'm sorry.
No, I'm sorry. I'm not being clear. It has nothing to do with the cyber squatting piece of it.
Okay.
It's the use after the site has been registered. So once you're within a particular category of goods and services, Tiffany can look and see who else is putting jewelry out in the world, or fake jewelry. And you can have a Beacon now, street gems, but they could still be putting out fake Tiffany branded stuff. And at least we can see within categories of services who's using their domain names for which purposes.
Yeah, I mean, my view on all of this is that there are probably lots more opportunities out there. I'd love to understand this, a little bit more to see whether it would actually help address the issue. But I think that brainstorming solutions like that are exactly what we should be doing.
I think that's a great idea. I think it'd be really hard to go back and do it now for everybody that's out there already. If you go to specialized top-level domains, that's kind of what you're talking about. So, for example, like a .travel, you can't get a .travel domain name unless you're in the travel industry and you show that you have legitimate credentials there. Same for .edu. Columbia University cannot get .edu without showing its credentials. So that does exist to some extent. That's a really intriguing idea. I think it would have great implications too, for example, in the privacy service context. So if I'm registering a domain name and I'm going to use it for my family, and I'm going to have pictures of my daughter on it, I would be able to get Privacy Shield for that, because there's a reason why I would want to have my address not on there. Whereas for a business, maybe they're not allowed to use a privacy service if their domain name is used in connection with a commercial business, and there's a real reason why. Folks who need to know who they are, along the lines of what you're talking about, with the Secretary of State filing. You have to have a real person with their name on there, so that if you want to file a lawsuit against them or otherwise get in contact, you have a legitimate contact information. So that's a really intriguing idea. I think it has a lot of kind of practical problems that I like the way you think.
So as was predicted, we have gone over a bit because there was a very interesting discussion generated by these two presentations, and we should thank our speakers.